we move on to the rules and an explanation of each of them, I just want to give you a high-level overview of what the core rules are. So basically, the first three are in some ways the ones that we will call the rules. They are that consideration must move from the promisee. Consideration needs to be sufficient, but it doesn't need to be adequate. And past consideration will never be good consideration. The next two rules that I have here, performance of or promise to perform an existing legal duty isn't a sufficient consideration, and past payment of a debt is never good consideration, really aren't so much rules affecting what consideration is, but tests as to whether the consideration itself is good consideration or not. So I just want you to take that high level, and I will go and move one by one through the rules. So firstly, consideration needs to move from the promisee. Have a look at the extract from Jenks in your casebook in Chapter 4. Actually, it's a textbook 4.4, I think. Basically, that provides that a promisor's promise can only be enforced by the promisee if they've provided the consideration for the promise itself. So let's unpack that because it gets quite muddled in some ways. Let's just think of a traditional bilateral contract where an offeror makes an offer that is capable of acceptance on its terms. I will mow your mother's lawn for $10. Do you agree? I offer to mow your mother's lawn for $10 if you agree. So that is a promise to mow your mother's lawn in consideration of the $10 price that you will be obliged to pay on acceptance of that offer. So my promise to mow your lawn can only be enforced by you if you've provided consideration for the promise. The act of accepting the offer and promising to pay $10 is in fact the consideration. The price that you pay for the promise is in fact another promise, a promise to pay $10. In exchange, if we flip that around, the promise that you've made me to pay me $10 can only be enforced if I have in fact provided consideration for that promise. In my case, the consideration is the promise to mow your mother's lawn. So there are two aspects of this. The consideration needs to move from the promisee. So we can look at consideration either way. Offer and acceptance, promisor, the offeror is a promisor, and the offeree, or the person accepting the offer, is the promisee. Consideration must move from the promisee, so the act of acceptance must involve, in that case, the taking on of the obligation to pay me $10. But it doesn't need to move, the consideration doesn't need to move from the promisor. So I'm promising to mow your mother's lawn. The benefit or the consideration flows from me to your mother, but the promise is binding on you because I'm in that combination, you're the promisor, the person promising $10. I'm the promisee. I'm saying the price for your promise of $10 is my offer to mow your mother's lawn, or my promise to mow your mother's lawn. The benefit actually goes to the promisee. Now, difficulties arise then because your obligation to pay me $10 will be a binding obligation. My obligation to mow your mother's lawn, also a binding obligation. But the only person who can enforce that promise is you, not your mother. So if I actually don't mow the lawn and you don't really care, but your mother does, your mother has what we call a privity problem with exercising that right. An important case in this area too is Coles and Baggett's Executor and Trustee Company. That's part of your reading. One of the things that shows us is that two parties to a contract might be joint promisees, and consideration might be provided by one of them on behalf of either both of them or all of them or just the one. We need to pick up whether or not consideration has moved or has not moved. Okay, the next rule, sufficiency as opposed to adequacy of consideration. The rule is essentially that consideration needs to be something that the law regards as valuable, but it doesn't require parity in value to the promiser's promise. So there needs to be an exchange of value, but the values don't need to match. It's for the promisor to stipulate the consideration for their promise, either directly or indirectly, not for the promisee to proffer something and call it consideration. Provided the consideration stipulated is legal, it can take virtually any form, and importantly, it need not be of comparable value. So, and as the video that David Goodwin has put up in this area talks about, a peppercorn can still be good consideration. And he talks about the events in the Bahamas, the annual payment of rent for the Masonic Lodge, with the delivery on a silver platter of a peppercorn every year. So the most famous case in this area is the Chapel and Nestle case. In that, or Nestle, I should say, in that case, Lord Somerville expressed the view that a peppercorn could constitute valuable consideration if it was stipulated by the promisor, even if the promisor wasn't fond of peppers and would discard the corn. In that case, throwaway chocolate wrappers, which were collectible by some people, could be sufficient consideration, even though to many others they were valuable. The case that I think is the most useful in this regard is Woolworths and Kelly, which is a decision of Justice Kirby, as he was then, and where he looked into the reasons why it's not appropriate for the courts to inquire into the adequacy of consideration. Have a look at the casebook at paragraph 4.8, and he lists out there the reasons for this. Firstly, different people will put different values on a bargain that they're getting for different reasons. People don't enter into a bargain for something neutral. Each of them believes that the thing that they're swapping is to a certain extent of greater value than the thing that they're giving away. I believe that there is more value to me or in acquiring this very useful little robot, where the salesperson in the robot shop believed that the, let's say, $1 million that I parted with to get hold of that robot is going to be of more value to them than keeping the robot on the shelf. Which of us is right? Oh, I suspect you'll have a view. But even so, it's not really for judges and lawyers to give opinions about the wisdom of bargains. That's not what the role of the court is. The role of the court, the role of the judges and the lawyers is to provide legal expertise. Thirdly, if courts were to assess the adequacy of consideration, litigation would involve huge amounts of evidence on the issue. One of the places where we see that happen is particularly in competition cases, where those of you who go on to study competition and consumer law will find yourself reading cases that go for hundreds and hundreds of pages, assessing days and days and days of economic evidence because of the things that the court needs to take into account in identifying whether anti-competitive conduct has happened. Even so, different judges...
You'll need to unlock your iPhone first.
Apparently. We might leave that alone. Sorry about that. If courts were to assess the adequacy of consideration, even so, different judges would reach different conclusions based on the same evidence. And that's contrary to this whole idea of the role of contract in providing certainty in relation to business decisions. Next, other areas of law provides means for challenging unjust bargains. So we can go to the law of equity, we can look at the statutes that deal with unconscionable conduct, we can look at the Australian consumer law and other things. And lastly, again going back to the role of economic freedom and contract law in the concept of economic freedom, in Kirby's view, parties should be free to make their own deal. Now, in theory, that all makes a great deal of sense, but all of us can reflect on recent contracts that we've all entered into, whether it's clicking I accept on an internet deal, entering into a new phone contract, purchasing electricity through a utility company. It's actually very rare for there to be that economic freedom and that parity where parties can make their own deal and have equal bargaining power. And again, going back to the earlier point that I just made, Kirby would argue and Woolworths and Kelly would support the proposition that that's not the role of the courts, that's the role of the legislature. So the next rule that I want to talk about is the past consideration rule. I think I'll move on to that in the next video though. And so, spoiler alert, past consideration is not good consideration.